Welcome to In Perspective, the podcast from Wilkin Chapman Rollets, where we take a closer look at the legal issues shaping today's workplaces. I'm Nicola Evans, a senior associate in the employment team, and I'm joined today by my colleague Molly Bloom. Today's topic is the Employment Rights Act 2025, and specifically the changes coming into force in April 2026. This episode kicks off our new series exploring the Act and what it means for workplaces. If you're an employer, a HR professional or business owner, this is essential listening, because the Employment Rights Act isn't just another tweak to existing legislation. It represents a fundamental shift in how employment rights are defined and enforced. In this episode, we're unpacking what these changes are, why they matter, and why companies can't ignore them. We'll explore the practical implications and highlight the steps that employers should be thinking about. You'll hear from Molly and I as we draw on our experience advising clients across all sectors, helping you understand not just the legal changes, but the real-world impact behind them. So grab a coffee and let's put the Employment Rights Act in perspective. Morning, Molly.
Good morning.
So the Employment Rights Act 2025, it's having a big impact on our working lives. Shall we just go into a bit about the background?
Yeah, absolutely.
Okay, so the Employment Rights Act was introduced in October 2024, shortly after the most recent election. It's in response to the government's plan to make work pay, which is a programme aimed at boosting wages, reducing unsecure work and modernising UK employment protections. It is one of the biggest updates that we've seen in our careers.
Absolutely.
It's building on foundations of earlier legislation, but it's modernising them for the world as we know it now. Why does the Act matter?
Yeah, so it provides a comprehensive update to the legislation from the 1990s. It builds on that earlier legislation, as you've said, but responds to the kind of shift that we've seen in the workplace to hybrid working, flexible working, digital work platforms, and the expectations around fairness and transparency in the workplace. So the Act responds to these structural changes that we've seen in the labour market and aims to create a level playing field for both parties. So where rights are clearer, enforcement's stronger, and there's less ambiguity. So for employees, I guess this will mean more rights and protections, but for employers, it will mean more obligations and potentially more scrutiny. So, yeah, it's a huge update that we need to be aware of. So what do you think are some of the key changes that are coming into force in April?
I mean, there's so many changes in the Employment Rights Act, but yes, today we're going to focus on the ones that are coming into effect first and those coming into effect in April. So we've identified 5 key ones to talk about today, haven't we? So shall we start things off with statutory sick pay?
Yeah.
So, statutory sick pay, this is going to have huge impact for employers. So, the lower earnings limit, which is currently £125 per week, is going to be entirely removed. So, from April 2026, what this means is that regardless of level of earnings, statutory sick pay is going to be accessible to, I believe the government estimates over 1 million more low earners and part-time workers who were previously excluded. This is going to have a big impact, in my view, on specific sectors such as tourism and leisure, hospitality, and retail. So post-April, SSP is going to be calculated on either the lower of the standard weekly cap for SSP or 80% of the employer's average weekly earnings. The second big change is that the right to receive statutory sick pay is going to become a day one right. So the previous, what we call waiting days, are going to be abolished. So day one right rather than day four, which has been the case.
How will that impact employers in terms of the removal of the waiting days?
It's a deceptively simple change that is going to have quite far-reaching consequences, because what this means, the most obvious impact is going to be an increased cost for employers, because they will be paying SSP from day one rather than day four. There's some additional factors too to take into account, perhaps that aren't financial. So organisations may see an increase in short-term absences. So perhaps previously where somebody would have come to work if they were feeling a bit under the weather, now they, knowing that they will get statutory sick pay, they may take some time off. Yeah. So the knock-on effect of that is twofold: potential increase in short-term absences, but also is there going to be a decrease in presenteeism, insofar as if somebody's ill, they'll take time off when they wouldn't have previously because they were worried about the cost. Yeah. So it might mean in due course that we have healthier workforces, but obviously there is that cost implication too. And I would recommend that all employers consider their policies, and particularly their sickness absence management policies. They might want to consider what absence triggers are currently. More focus, I think, needs to be placed on return to work interviews, ensuring that employers understand the reasons for sickness, to ensure that this new right isn't taken advantage of. And I think most importantly, ensure that managers are trained in conducting return to work interviews to ensure that nothing is missed, so that the employer's got a good overview of their employees' overall health. Yeah. So that's a really interesting one, and I'm interested to see how it plays out in the real world. There's some more day one rights coming up. Yeah, absolutely. So the Act will bring into force some changes around day one family leave. So firstly, there's paternity leave, which currently requires a period of 26 weeks service up to the 15th week before the expected due date in order to benefit from statutory paternity leave. That's going to be removed and it's going to become a day one right. So then obviously more employees will have access to that immediately. Similarly, unpaid parental leave. So that currently requires a 1-year continuous service requirement in order to benefit from the unpaid parental leave right. Again, that's going to become a day one right. So again, immediate access and flexibility there for employees. So you can see how the government are trying to implement that with the Act. Yeah, there's a bit of a theme showing, isn't there? Absolutely. So that the actual rights aren't changing, are they? No, so yeah, as you say, the rights aren't changing. They're just going to be accessible from day one rather than having to have that requirement of the continuous service. So government guidance has suggested that this will mean 1.5 million people will have immediate access to this right. So again, just bringing in that flexibility element there that the Act intends to bring into force. There's also another form of leave that will be available from day one. So there's bereaved partners paternity leave. So that will mean that employees will have up to 52 weeks of leave where the mother or primary adopter dies within 1 year of birth or placement. So, yeah, in reality, it's just bringing in some more rights for employees there from day one of employment. Okay. And what do employers need to do to prepare for these? So more employees are going to be immediately eligible for these rights, so they need to be aware of that and prepared for the influx of requests that they may well see. So they need to ideally train managers of this new eligibility criteria to avoid any accidental refusals that could have, consequences further down the line. Reviewing policies and procedures to obviously make sure that they're reflecting these new rights that we're seeing that are coming into force.
there will be some cost implication potentially in terms of onboarding processes to cover some, to hire some cover or replacements if required. But in terms of the actual cost associated with the leave, I don't think that's going to drastically change what we're currently seeing. Because, for example, paternity leave, although the leave will be a day one right, the statutory paternity pay will still be as it currently is with that 26-week service requirement. Unless employers choose to obviously bring it in line and reflect the day one eligibility, that will still remain the same. So in terms of the pay for the leave, I don't think that's necessarily going to cost.
Yeah, I agree. I think that's what I'm seeing too.
Tell me a bit more about the collective redundancy changes.
Yeah, this is quite a big change that employers do need to be mindful about. So currently, collective redundancy consultation needs to happen where 20 or more employees are to be made redundant at one establishment within a 90-day period. If an employer fails to collectively consult with its staff in a proper manner, tribunals can award a protective award currently of up to 90 days pay per employees. So even now, based on the current position, this is a substantial award. It's one that has a lot of cost implications. The award is uncapped, so it's 90 days full pay. And as of April this year, that award is going to be doubled to 180 days pay. This is a significant escalation. So the cost ramifications for not undertaking a thorough collective redundancy consultation period have doubled, in effect. The maximum liability is up to 6 months' pay per employee. And tribunals do frequently award the maximum amount whereby little to no consultation has taken place. Yeah. So in terms of what this means for employers, firstly, it's going to be absolutely imperative moving forwards that companies are aware of the requirements of a collective redundancy consultation process and ensure that they accurately follow the letter of the law, so to speak, in that regard, to ensure that they don't fall foul, because the cost implications are huge, or are going to be even bigger from April.
Yeah. So will this have more of an effect or impact on employers with more than one business premises?
Yes, absolutely, but not immediately. Obviously, I've just mentioned the financial risk of getting consultation wrong is going to be dramatically higher. But from 2027, so we're straying out of the changes that are coming into force imminently, it is highly likely, the consultation is currently ongoing, that the one establishment test is going to be removed, and therefore employers are going to have to collectively consult with each individual location, and the total of employees who are at risk of redundancy will be aggregated. So as a result of that, it's likely that there are going to be more instances of collective consultation necessary. So in my view, it would be really good to be a little bit more forearmed, and for companies to understand what collective consultation means now, and ensure that they are prepared and ready for when that extra change comes in, which is going to be sometime next year, we believe.
Yeah.
So what's the fourth point that we are talking about that's coming into effect next month? There's some there are some increased, strengthened whistleblowing protections.
There are, yes. So raising concerns that sexual harassment has happened, is likely to happen, or is happening will be recognised as a protected disclosure in its own right, so protected from whistleblowing law. So currently, individuals would likely have to argue that it fits into a different category under whistleblowing law, for example, health and safety or criminal conduct, whereas it will now be protected as a relevant disclosure in its own right. So there'll be clearer safeguards and explicit responsibility placed on employers to deal with it appropriately.
Okay, so again, not a fundamental change, but just one that employers need to be aware of, because I can imagine in such a situation this is going to perhaps give employees the confidence to report unwanted conduct more.
Yeah, I think that is the government's aim here, and it's the intention. So there are statistics out there that say that 26% of people who have experienced sexual harassment have done so in the workplace, but only half of them have reported it because there's a fear of victimisation or lack of trust in the process. So I think this change here is really trying to encourage earlier reporting and make employers take it seriously, and hopefully create that cultural shift that we want to see in terms of confidence in the process and people coming forward if they have suffered from this and know that it will be taken seriously and it will be dealt with appropriately. So I think that's the intention behind this change here. So yeah, although it doesn't necessarily change the legal framework in terms of whether it is protected under whistleblowing law, I think given that it's protected in its own right, will hopefully just encourage that confidence in the system.
I would completely agree. I think this is a bit of a common theme. Obviously, there's been other changes in relation to sexual harassment, and everything is going in the direction that companies have to take positive steps to prevent this from happening. So there's an ongoing theme there. So I think in terms of how our listeners and our clients can prepare, it's about creating that open culture within a workforce and making it clear that such conduct isn't going to be, it's not going to be acceptable within a workforce.
Absolutely, yeah.
So the final change that we're going to talk about is the introduction of the Fair Work Agency. So this is a new government agency that is going to come into being on the 7th of April. It's going to be a single enforcement organisation that's going to have enforcement powers over enforcing rights in relation to statutory sick pay, to holiday pay and to the national minimum wage. So it's consolidating all of those previous functions which were dealt with by other individual bodies under one roof, so to speak. The agency is going to gain more and more rights, in my view, as time goes on. We don't have exact details of them as yet, but there has been a number of discussions surrounding the fact that the Fair Work Agency may well be able to bring claims on behalf of employees in due course. I mean, that's one to watch out for and would mark a huge shift in our world. But in terms of what our listeners and what our clients need to know now, the crucial thing is that the Fair Work Agency is going to have a lot of enforcement powers over compliance. So what can you do to prepare? I would say ensure that you have clear and accurate records of sick pay, national minimum wage and holiday pay. Look at the way holiday pay is recorded. It is perfectly acceptable to mark holidays on a calendar on the wall, but think about how that can be retained. So think about updating systems, ensuring that whatever payroll software is used can be updated to reflect, for example, the changes that we've just discussed in relation to SSP, because the Fair Work Agency is going to want to see this information. Yeah,
absolutely. So what do you think the government's aim is in relation to this Fair Work Agency?
I think there's a common theme throughout this Act. It's transparency, it's adapting to a modern workplace. Workplaces today look very different to what they looked like in 1996 when let's call it the original Employment Rights Act came into being. And it's adapting, and I think the Fair Work Agency is a response to that, and it's showing that employers are going to have to be more accountable, and I think that's very clear. given the powers that the Fair Work Agency has, there is a theme of accountability. So, it's not just admin that needs to be retained, it's evidence that needs to be retained to ensure that if any claims are brought, that companies can adequately respond to those claims. So in terms of what should companies be doing now to prepare? Obviously, we don't have long now until April. It's a week or so away.
Yeah.
So, the time since this Act was introduced in October 2024, we felt that the process dragged through the House of Lords, but time is passing very quickly since the Act received royal assent. So in terms of some practical takeaway tips, what would you say? What have you been saying to our clients?
I think, as we've said throughout today, really, it's always important to review all the contracts and policies and make sure that they're reflecting the legislative changes that we're seeing and making sure they're up to date. Updating onboarding processes. So as we've seen, there's going to be a lot more flexibility for employees and a lot more day one rights. So there might be a requirement to hire more replacements or make sure that you've got that cover in place for those different types of leave. So onboarding processes will be really important.
Yes.
Auditing worker classifications, strengthening hybrid and flexible working frameworks. I think overall training managers and the right people on the new obligations is going to be really important.
I would agree. In my view, I mean, training managers is absolutely key. That's the one thing I've been talking about to my clients who have been asking me about the implications of the Employment Rights Act.
Yeah.
If managers know how to deal with situations, or at the very least they know that a change is imminent or has just taken effect, they can at least speak with the relevant person, whether it be a HR manager, a direct report, to seek more advice to ensure that nothing goes too drastically wrong.
Absolutely.
So I think the message is clear from the Employment Rights Act. Adapt early, and you're going to be on the right lines. Ignore it, and there could be some quite significant potential consequences.
Yeah, absolutely. Yeah.
So thank you for listening. The next episode on the series in the Employment Rights Act is going to be on the world of unfair dismissal. So thank you very much.
Thank you.